It is our absolute pleasure to welcome Dr. Laske here for our first seminar of term. We are very excited to hear about the intersection of legal history and linguistics, and we look forward to a wonderful seminar. So without wasting everyone's time any further, I will turn it over to Dr. Laske.
Well, thank you very much for the invitation, and I'm particularly thrilled to talk to you today. Also because, of course, I'm a Cambridge alumni, and the thing is that I was introduced to legal history by Peter Stein, who taught me in one of those wonderfully wooden panelled rooms in the Squire Library. And that's where I first discovered how wonderful legal history is. And so I would like to dedicate this talk today to him, because I am very grateful for all the inspiration that he gave me and on these occasions during that time when we talked together. Okay, so now you can see my slide. It looks very different from when I sent it, from my original one. So I hope it's not too distorted. But anyway, we'll go ahead. So my research interests lie at the intersection of law, history, and linguistics, as Douglas already said, and I have a general interest in languages. My underlying approach is to study the law by the way it is expressed, mainly through language, though other means obviously are also interesting to examine, such as discourse communicated through pictorial representation, for example. I'm currently looking at the Sachsenspiegel, which is can be seen as akin to a bilingual edition of the law book, because its pictorial parts are of similar prominence to the text. Can you put the next slide, please? So to approach law from the angle of language, whether within legal history, legal theory, or comparative law, is to mark out a research field that goes beyond content analysis. On the one hand, you have the inquiry of the legal scholar that reveals the legal thought, doctrine, change, and application. And on the other hand, the study of language in the legal context shows how law was encoded in linguistic expressions and meanings. And bringing the two together allows for a better understanding of the continuous interaction between the way legal thought creates meaning in language, and language in turn creates realities and law. Next slide, please. So in today's talk, I'm proposing to discuss the use of linguistic disciplines as cognitive models for legal history. In other words, this talk is about methodology. Particular attention will be paid to the use of analytical linguistics and digital corpus and concordance-based methodologies that enable us to gain a deep level understanding of the origins, evolution, and change of legal thinking, the law, and its terminology. So at this stage, I would like to stress that the language of the law is not as such the object of my study, and my use of linguistic methodologies is not an aim in itself, but rather these are tools and methodologies that reveal patterns in legal language use and ways of encoding meanings. So this kind of information can be generated because electronic corpora allow us for access to a lot of data. And it is important to point out that this approach can obviously be applied to all historical periods and need not be restricted to the centuries, nor to the types of law that figure in the 3 studies that I will be discussing later. Next slide, please. So I'm structuring my talk in 4 parts. First of all, a brief description of the view of language that I take, then an overview of and an explanation of what corpus linguistic consists of. So there's a large body of literature that describes in detail the possibilities of how to constitute and exploit a corpus, as well as more technical aspects of the kind of software used. And if you want any references, then I'm very happy to provide those. Just ask me or send me a mail or during our discussion afterwards. Then I will be discussing 3 historical studies that I did using corpus linguistics. The first one relates to conceptualization of a legal concept, the second one to a new area of law, and the third one to the textual representation of a particular group of people in customary law. Next slide, please. So just quickly to set off with language, the underlying premise in relation to language I have adopted is a systemic functional one, meaning that language as a pragmatic act of communication fulfills the social function, namely the use of language when people interact with each other. In other words, the way meanings are given and encoded is directly related to how experience of reality is represented linguistically. These experiential meanings are thus conditioned by the socio-political, cultural, and historical contexts in which they are uttered and become in turn reliable indicators of these contexts. The pragmatic approach to language use also implies a recognition of semantic shifts or changes in linguistic conventions over time. The corpus and concordance-based methodologies offer a series of tools that can contribute to revealing how meanings are encoded and how these have evolved diachronically. Next slide, please. So corpus linguistics, Stubbs has defined that as an empirical approach to studying language, which uses observation of attested data in order to make a generalization about lexis, grammar, and semantics. And I'm taking that, but I'm going in legal history, for the legal history purpose, I'm taking that a step further, and I'm drawing conclusion from those generalization about lexis, grammar, and semantics about the law. So I'm taking that and use that data to draw conclusions from the law. Next slide, please. So corpus-based research is a study of language based on large collections of computerized data, while concordance-based study is the use of linguistic software that retrieves alphabetically or otherwise sorted list of linguistic data from the corpus in question. These methodologies and tools allow us to examine the language in its textual context by accessing large bodies of electronically held text of naturally occurring language. Such criteria can then be determined with a few mouse clicks, making it possible for detailed searches of words, phrases, and lexical or grammatical patterns and structures, and this in multiple contexts and among a large amount of electronically held texts. This provides information on the data that is both qualitative and quantitative, empirical rather than intuitive. Because intuition, we all have intuitions about when we read texts, and we may have intuition of relative frequency of words, of phrase and structure, but these can be vague and too general to be relevant. So while we are aware of the frequency of lexis, it is highly unlikely that we have a precise intuition about the exact frequencies, for example, of grammatical categories. Used as an empirical basis for studying language in use, corpus and concordance-based tools generate new ways of studying meaning and language in context. It can be used for purely descriptive purposes that are ideological more neutral, but it can obviously also be used to support discourse analysis. Next slide, please. So in other words, a corpus and concordance-based studies examines language and terminology in context. And from studying the context, we will also learn about the word meanings. If a word has several meanings or meanings have shifted throughout time, we will find the tendencies for each meaning to be associated most frequently with different patterns. Consequently, words which share a pattern also tend to share aspects of meaning. The British linguist Firth famously wrote, "You shall know a word by the company it keeps." And that is exactly what corpus and concordance-based studies provide. the information of the company that words keep. So despite the increasingly widespread use of corpus linguistics in many fields, many law-related areas still tend to shy a little bit away from exploring these type of methodologies to provide context. However, it does have, as far as legal history is concerned, quite a lot of interesting applications. And I repeat again, it's not an end in itself, but a means for this, it is essential that the use of such tools need to be preceded by specific research questions. And then the resulting data that can contribute to the overall research can then feed back into the research questions. So we can say that there are as many applications as there are research questions. So in legal history, a primarily content-driven approach aims to establish historical legal facts, theories and doctrines, which usually involves the study of text and sources, at times on a comparative basis, including their history of origin or reception and application. While terminology is regularly a subject of inquiry, linguistic analysis can offer so much more than merely a better understanding of the terminology and its evolution. The contextual dimension of the "you shall know a word by the company it keeps" approach can be applied by analogy to a better understanding of legal phenomena, developments, and texts by the words in which they are expressed. So corpus and concordance-based methodologies and tools allow for an enhanced understanding of the words, the company they keep, and the meanings they encode, as well as what people have done with the words and the meanings. Next slide, please. So this was all rather theoretical. Let me come on to talk about 3 studies that I did. So the first one will be dealing with the legal concepts and terminology, and I'm referring to the concept of consideration, the common law of contract. Then we will move forward to the 20th century, even second half of the 20th century, and talk about environmental law concepts, so a new area of law. And then we'll be going right back into the 13th century and talk about legal capacity and the way women are legal capacity of women is represented in les Très Anciens Coutumiers de Normandie. Next slide. So I'm obviously, these are obviously very long. Some of these are very studies which have been undertaken over several years. So I'm just going to skip through some of the interesting things, not more in order to show you what we can do with this type of methodology. If I was to talk about every study, I could do a whole lecture on every study in specifically. But here, I just want to give you an overview, really, of what this can be used for. So starting with the premise that law is not just a set of natural facts, it can be seen as more akin to an interpretive reality that invests material reality with specific significance. Pivotal in this construct is the use of language, as it is the linguistic expression of this man-made phenomena that cannot be verified as such as physical facts, but evolve in interpretive realities. Consequently, the materialization and evolution of legal concepts can be understood more comprehensively by analyzing the language that is used to express them, in particular when they are considered diachronically and/or comparatively. In other words, tracing the historical process of legal thought, including the conceptual shifts over time, can also be revealed by studying the relevant language and ways of encoding meaning in parallel to the usual content analysis. This approach is akin to the Begriffsgeschichte work undertaken by the German-speaking academia. Traditionally, the concept of consideration in English common law is the element of contract formation that makes an informal contract legally enforceable. A promise was considered as a prima facie binding if it was supported by some sort of consideration. The forerunners of consideration arose in a medieval legal world with archaic procedures and complex technicalities, where there was an increasing need for a mechanism that would meet growing commercial demands in terms of contract and quasi-contract. It was no longer enough to just rely on executory contracts on the one hand and on deeds and covenants on the other. Flourishing trade required tools to make promises legally enforceable, and the concept of consideration emerged in that context as a check that would ring-fence the possibilities of bringing an action for a breach promise. So it's important to remind ourselves that this concept has a long history of piecemeal legal rules gradually coming together over several centuries to form a legal concept. And incidentally, this is reflected in the terminology, which settled only hesitantly and shows a concordance between the complexity of the concept's evolution and the terminology used to express it. The object of the research was to study precisely that process of bundling together a collection of rules into a legal concept. And this was done through examining the language used as an indicator for that particular process. In other words, at the heart of the study was the extent to which the historical and conceptual development of the concept of consideration were matched by changes and shifts in language terms and lexical fields, most notably in relation to the increased abstraction and technicality of both concept and language. And then, of course, also relevant in that context is the linguistic landscape of multilingual medieval England and the continuous switching between Low French and Middle and then later early modern English. Next slide, please. The study on the doctrine of, so this study showed us that while the notion of legally enforceable informal undertaking and promises emerged in the second half of the 14th century and gradually became a legal reality, the textual evidence until towards the end of the 16th century does not show definite new legal technical terms or categories, nor does it show the vocabulary in the actions to be particularly uniform. The language used still related to the past proprietary element of an exchange rather than to the new concept of a promissory undertaking. There are repeated references to covenant, bargain, debts, which are all notions emanating from the older actions, and appears as though the new legal thinking could not overcome old established categories of proprietary concepts. The terminology used remained on well-trodden paths. So, for example, the term promise and its underlying notion only figured tentatively in the case law. Yet with today's hindsight, we understand that promise was actually already at the heart of the new legal thinking, and the fact that the terminology lagged behind the development of informal contracts from a conceptual point of view highlighted the concordance between the complexities and difficulties to establish this new concept and to find appropriate terminology. So what I haven't said is that the corpus was, I constituted the corpus, and that was all based on case law. Next slide, please. So the second observation that could be made when specifically studying the term consideration diachronically is the semantic shift towards legal technical meanings that happened in the linguistic continuum from the 16th century onwards. The study revealed the process of increasing terminological abstraction alongside the consolidation and development of the legal concept. In the first period, there is an increased use of the collocation "in consideration of" as a causal conjunction between the two elements or events necessary for striking a contractual agreement. While this particular collocation could be used in any situation of exchange, the textual context clearly showed that we are dealing with specialist technical matters of the law. It is relatively restricted set of vocabulary concerned with legal instruments and persons or payment or indenture, etc., in exchange or in consideration of mainly marriage and other family matters. In other words, both the meaning and function of the collocation is in a general language sense, but it is the lexical and semantic context that is highly technical. As we then move further into the 16th century and towards the 17th century, we find consideration in technical uses. The lexical variety of its textual context is relatively poor and semantically restricted. The term consideration tends to be combined with a limited set of words, which is indicative for the use of specialized language. Furthermore, it starts to appear as a full noun, consideration, and a function of participants accompanied by adjectives or prepositions and associated with verbs. The term can also be found as a one-word sentence where the word is between two full stops and thus invested with conceptual meanings. All these grammatical pointers put the word consideration in prime position within the clauses, a position where it appears in its own right and as a signpost for a concept rather than just as a mere causal link between two other prime elements. And it is in that sense that the word is used in a way akin to a concept. And as the concept was tried out and discussed and challenged in the courts, it became more established, and so did its position as an autonomous concept. And this was reflected in the use of the term consideration, no longer solely in the context of a causal connector, but as a standalone noun and cover term for the conceptual thinking of how to make informal agreements enforceable. So the term consideration stood hitherto for a legal concept that then obviously continued to evolve to the present day. Now, next slide, please. So this process was revealed obviously by this diachronic semantic corpus and concordance-based study, and on a purpose-built corpus of vernacular language law reports. And the specific examination of the textual context surrounding the term consideration can be observed on the slide that you can see now. So that is just an example, and it's a presentation, what you call a KWIC presentation, keyword and context presentation. Where you can see, this was more just in order to show you what it looks like. So you've got the term, the search term consideration, which is in red. Then obviously normally your lines are much longer, but they couldn't be put into a slide. So I just cut it. So then you can sort it alphabetically. In this case, I've sorted it alphabetically, starting with the word in front of the search term, and then in a second position the word afterwards, and that allows you then to really put together. So this type of sorting mechanism allows you to sort of see the specific structures all in one go. And of course here we've only got 10 lines, but I mean some of these studies you have hundreds, thousands, 10,000s of lines. So that's a very good way of seeing the same type of structure all clustered together. Okay, so next slide, please. So then I've got all these quick lines, and then so what I did is I grouped together these lines into 4 main language registers, though no doubt there is some overlap between the categories, and the divisions may appear somewhat artificial at times, but well, you've got, for the purpose of such a study, you've got to somehow make some group them together in some way for evaluation. So what I chose to do was I had the first is the general language meaning or use, so that is language comprehensible to anyone, to the ordinary person. An example would be the court case, the court decision was made in consideration of all the facts. I think we can agree, everyone can understand that fairly easily. So then there is a second category, which is what I call general language meaning but use in a legal context. So that is still comprehensible to all, but the specifically legal context or dimensions in which this language occurs adds legal meanings, and that may only be picked up by those with some legal training. So if we have the payment was promised in consideration of the marriage to his daughter, I think most people will understand that, but maybe the legal dimension and content will not be necessarily picked up in the same way by someone who has got some legal training. And then the third category, which I call specialist, technical, or abstract meaning and use, that is obviously the language is abstract to a point that its meaning can no longer be understood by a non-specialist. An example would be the instrument imported a prima facie consideration. And then there was a fourth category, which is all the Latin uses. So next slide, please. So here you can see very nicely how this, so I've got these 4 categories I've just described. And here you can see how moving through the centuries, how the word consideration and its context changes. So while in the 14th, 15th century, we are still very much in a general language use of the word consideration, that then drops considerably as the centuries go on, only to 2% in the 18th, 19th century, and the very technical use of the word consideration in the 18th, 19th century, 83%. So that is where you can see how that has moved, how this word is being invested with very different meanings as you go along throughout the centuries. Next slide, please. Yes, so with that comes back, now you understand why it's blue and yellow and green, and that is exactly, it refers to the previous slide. So the chart has shown that how in the use of the terminology that encodes the concept of consideration, we have therefore shifted along a linguistic continuum from consideration as a general concept to consideration in a general context. That was the blue one, and then in consideration in a specifically legal context through to consideration just as a linguistic expression of the legal concept, which was in the green bit of the previous slide. Okay, so much for the study of consideration, which is, of course, as I said, much deeper, but it was just a way of showing what you can do with corpus linguistics. Next slide. So let's move on to a new and very different area and a different perspective, a very recent new area of law that has developed exponentially over the last few decades, and that would be environmental law. In general, the subject of the environment can boast an impressive diversity of ideas, concepts, and points of views, etc. As a body of law developed in a short period of time, environmental law did not benefit from a more gradual organic evolution in view of the rapidity and urgency and political context and content. And the downside of that is arguable that the content and legitimacy of the underlying concepts and principles of environmental protection and governance have been given insufficient attention and time to evolve. In the presence or absence of such legal conceptual underpinnings that will condition whether environmental law develops into a fully fledged or permanent body of law, or whether environmental protection is to be merely a factor in a problem-specific context that will be taken into account in a diversity of established substantive contexts. So in the development of what we call environmental protection policy and law, we can observe how certain concepts and the semantic meanings of the language used to describe them can differ substantially from one region of the world to another. For example, the concept of person is defined differently depending on the legal context. In most civil and common law systems, it relates to a legal entity, an abstraction or a fiction, whereas in legal traditions such as in the indigenous law in Canada or New Zealand, it can refer to real entities of land, as for example, the legal personality of a river. So this illustrates how the understanding of what constitutes the environment and our relationship to it are different depending on the legal context. Revealing such differences can help identify not only law creation and implementation, but inform us on the ontological basis underlying specific legal concepts. In the case of the legal personality of the river, both meanings find expression in positive law. And this raises the question of whether and how the positive law can articulate both concepts, or whether there is a need to reconsider the concept and its ontological foundation. Moreover, in an international and supranational context, legal concepts and terms can be used differently in different languages, and examining the semantic content can provide deep-level understanding of such differences. And that may be useful, for example, for legal harmonization projects. Studying diachronically the language and terminology used in relation to environmental protection and governance by searching both a general language corpus and an environmental law corpus offers some insights into how these ideas and concepts developed. The underlying premise is again a linguistic pragmatic one, namely to consider the linguistic expression of and reliable indicator for underlying conceptual thinking. For that purpose, it is interesting to search the corpora for terms generally associated with environmental protection and governance. In this process of rapid expansion in the discourse, the language and terminology used often evolve by adapting existing terms to new concepts or by creating neologisms. Next slide, please. So in the general language corpus, which I chose the British National Corpus. The result for the search term environment was particularly interesting. It shows a number of meanings, of which the effect of human activity on the environment is only one. So that's how we today think of environmental policy, but that's actually only one. So you can see from the slide that during the 60s and early 70s, the term environment was used almost exclusively in a general sense, relating to social, economic, political, health factors and conditions, while in only very few cases does it refer to natural, biological and chemical environments. The concept of environment as the effect of human activity on the environment was totally absent in the text of that period. The first shift then towards understanding the environment as the effects of human activity on the natural environment can be observed between the mid-70s and mid-80s, where 3/4 of the occurrences of the term relate to a general sense and 6% to a natural scientific context. However, we do now find that in 16% of the lines, environment is used in relation to the effects of human activity on the environment, and 2% refer to titles such as government departments or ministers, etc. And then the substantial change then comes in the third period, which is the third column, late 80s and early 90s, when the general context uses have fallen to just a third. The scientific context uses remain a very small fraction, while the uses in relation to the context of effect of human activity on the environment and to specific titles represent over half of the occurrence of the term environment. So this linguistic evidence would suggest that this particular time, it was during this particular time that the concept of environment, as we think of it today, took on and consolidated the specific meaning relating to the effect of human activity on the environment. So then the equivalent study on the basis of legal text was more complex because there isn't a corpus readily available, and it had to be purposely built. For that, I used the Ecolex database. And there we find that in contrast to the multitude of meanings that could be found in the general language corpus, which I've just mentioned, the textual context of the legal corpus showed the language and terminology semantically restricted to the issue raised by the impact of the human activity on the environment. And all terms examined in the studies collocated and clustered with typical environmental protection terminology: protect, protection, health, effects, impact, water, land, noise, nitrates, agriculture, etc. Also prominent were terms relating to political, administrative, or legal structures set up as part of the environment protection policies. Unsurprisingly, the most common terms of environmental law are also those that show the highest frequency, such as environment, land, pollution, waste, water. Three notable exceptions that have commonly been associated with the early environment case law in the common law are nuisance, negligence, and contamination. It is some indication that the approach of litigating early environmental contamination cases through the common law of nuisance and negligence did not persist on a worldwide level. The figures would no doubt be slightly different if carried out on a corpus that only contained text of common law cases. Similarly, other legal traditions such as indigenous law in the United States, Canada, or New Zealand may place different emphasis and or introduce other concepts such as Mother Earth. That is certainly a concept in some of the indigenous law. The general increase in both the occurrence and diversity of the terms show an important expansion of environmental law, language, and terminology, and long-established preoccupation with issues relating, for example, to land, pollution, and water continue to be discussed and are superseded by newer concepts. Okay, so let's now move back. Next slide, please. Move back and have a very different type of study where I'm looking at textual representation of a particular group of persons in customary law. So this particular study considered how the textual representation so the purpose of the study, as I said, was to provide data of how women were textually represented in the Ancien Coutumier de Normandie, with a view to evaluating their legal capacity, the legal capacity they enjoyed or lacked, and the extent of their legal dependency on the male members of their family entourage. The term was searched, the The term was, the term was searched more specifically, the text was searched more specifically for terms that are likely linguistic expressions for women's legal position, or would reveal such positions. In the case of some keywords, these results were compared to equivalent terms for men. The descriptors can roughly be classified into three main groups, as you can see on the slide. So moving from the central to the peripheral, at the center being relating to the woman as her own person, then moving on to the definition of herself in relation to others, sister, daughter, mother, etc. And then on the peripheral, the outer peripheral level, we find language that relates to her legal or marital or sexual status. Also included in this category are terms that are commonly found in the context of women's property rights, such as, for example, dower or inheritance. Next slide, please. So what you can see from the word list that was produced by the software on the basis of the Coutumier corpus, we can see that there are 10 categories of descriptors for women from among a total of 215 occurrences. You can see that. So you've got the 10 in the chart on the left. You've got the 10 descriptors, and then it's the 215 occurrences. So this involves she, woman, sister, daughter, mother, widow, girl, eldest, virgin, cousin, etc. And in contrast to that, you can see that there are 21 categories of descriptors for men, and those totaling 1,154 occurrences, and for a greater variety of terms than used to describe women. From these figures alone, we can observe that the male voice is far more prominent than the one relating to women. The pronoun il is ranked second on the word list, which is approximately 8 times as frequently as its female counterpart elle. However, it is interesting to observe that there is also a greater variety of categories of descriptors for men than for women. In other words, not only is there a considerable greater presence of the male voice in the text, but it also reveals that men have a greater variety of roles. The reference to women are always in relation to their family setups or their marital status. Women are sisters or mothers or daughters or cousins or widows or virgins, etc. 9 categories in all. Their social status is revealed through family and marital status, never through anything revealing any other kind of status, such as power or possession or professional activities. Terms that express some kind of female lordship or hierarchy are entirely absent from the text. Men, on the other hand, are identified in relation to a number of roles, 12 categories in all. And beside the family relation, such as descriptions such as father and brother and husband, etc., men are listed in relation to socio-political and religious power, such as king and earl and knight and bishop, etc. In other words, the narrative told in the Coutumier is not only more the narrative told of men, in the Coutumier is not only more substantial, but also considerably more varied and thus contextually richer. Next slide, please. So you can see that is how this is borne out in the figures in this particular chart, which details some of the gender descriptors. We can observe that the term femme not only occurs considerably less than its male equivalent, homme, but approximately as often as duc, and only slightly more than roi. So in other words, in a generic term, as woman is, that describes approximately half the population, occurs roughly as often as the term duke, which is used to describe only one particular person or office in Normandy. Next slide, please. Yep. So despite the considerably higher textual presence of references to men, we can observe from the proximity searches that certain terms referring to matters of a legal nature can be found far more often in contexts relating to women than men. While we may expect to find references to women mentioned more often in discussions relating to dower or the third of her husband's estate that she can expect will be settled on her, it is surprising that the terms héritage and mariage are also predominantly associated with women. One would expect men to be involved as much as women in matters of inheritance and marriage, but the proximity figures do not appear to bear that out. It would therefore be reasonable to conclude that discussions of marriage, inheritance, dower, and the third settled on married women mainly relate to women. A closer look at the textual context in which the terms femme and homme occur confirms the finding of the proximity studies. You can see that on the slide. In over half of the contextual lines for women, the context relates to matters of inheritance, family, dower, or marriage. However, issues of land and property, although at the heart of discussion about inheritance and dower, are more associated with men. So are court and legal proceedings, crime and violence, as well as matters of political power or feudal homage and duties, and that last category is totally absent in the contextual lines for femme. A detailed analysis of the contextual lines also reveals the type of processes with which the search term associate. Without going into any specific statistics, it can be said that the female descriptios tend to be governed by verbal groups that reflect a more passive rather than an active aspect of the experiential world. The use of corpus linguistics in this particular study has revealed that the female voice is rather feeble in the coutumier, which is particularly striking in the comparative data sets that highlight the extent of the discrepancies, which is set by side with the equivalent male terms, as you can see here and in some of the other charts. So much for so that's the end of that study. So much for showing what can be done with corpus linguistics in legal history. So in conclusion, we can ask ourselves the question, why is corpus linguistics important for legal history? Well, it allows us to go beyond the content-driven research and provides us with data of how meanings are or were encoded at a given moment in time or diachronically over a given period of time. And this informs us about specific points in time, including the present, or provides knowledge for a historical understanding and in relation to both the semantic and conceptual shifts that may have happened over time. So it is, however, important to stress, and I'm stressing it again, that the linguistic methodologies should be used as tools to indicate tendency in law and legal thinking. And to that extent, these are tools that have to be preceded by specific research questions. For these linguistic possibilities to become more widely used, it is not only essential that the methodologies become more visible in legal research, teaching and practice, but also that corpora with legal language registers should become more widely available. The nature of legal language is very specific, and the use of a general language corpus is usually not appropriate unless specifically formulated by the research question. For the moment, databases with legal text were all compiled for the purposes of accessibilities for legal scholars and legal experts. The databases were constituted with a view to answer the needs of these type of users. But it means that the application of corpus linguistics on such texts can require purpose-built corpus, which is very time-consuming. So there's an urgent need for legal scholars to be built, for legal databases, to be built in such a way as to allow for the possibility of using them in conjunction with linguistic software without having to first constitute a separate corpus. Next slide, please. So I think the best conclusion really is we have to take our cue from Humpty Dumpty, who says, well, when I use a word, it means just what I choose it to mean, neither more or less. Thank you for your attention.
Thank you so much, Dr. Laske. That was absolutely fascinating, both the methodology and the presentation. We will now open it up to questions. If you don't mind, I will take the first one.
Yes. Can you maybe, should we not share that screen anymore, or?
Yes, it should be. And I apologize again for the technical difficulties. I was in particular interested by, in the early part of your discussion, the interplay between the ossification of the lexis itself and the concept that kind of it represents, that underlies it. And I'm curious how that might interact with the fact that certain phrases have remained in Latin and French to this day, and to not develop any kind of English term that would be used to represent them in that fashion. Is that something that did come up in your research at all, or is that not?
Well, that wasn't part of the research question, so I wouldn't. I mean, I think you can do that sort of. You can use corpus linguistic to do this, to highlight what you've just said. It wasn't part of mine. I think really that is a whole. The evolution of the terminology and the use and what comes over from the law French is very interesting, and it would be a very interesting thing to actually indeed take these do a sort of a diachronical study to see what has been taken over and what hasn't. So but it wasn't part of what I did at this stage.
Do we have any additional questions? I could just be missing the, if you could just use the reaction.
I'm not sure how you put your hand up on this.
That's very good. That's an excellent way of doing it.
Can I just ask a question without putting my hand up?
Please.
It seems to me that your results depend a great deal on what corpus of text you choose.
Absolutely.
And if you take, for instance, the history of consideration, I think the growth of a technical meaning is going to be found more in the Latin plea rolls, which are unpublished, than in the English. I say English, English are translations of French for the most part. And then the story then is going to develop in the unpublished French law reports of the later 16th century. So if, and I don't know which text you did use, but if you're just taking the English reports, for instance, it's going to be a very partial selection of texts, which isn't going to tell you as much as we discover by ploughing through plea rolls and manuscript law reports.
No, yes, no, that's a very, very good observation. And that really is one of the, that's what I said in the end, you know, if we don't have access to the sources, you know, in a wide range, then that is a restriction indeed. So I think what I think is what I said earlier is that this is not an exact science. I think it's going to show us tendencies, and one of the things, of course, I couldn't go into all the details of what sources I used, how I used them, and so on. So that wasn't possible here within this talk. But I think what you can do is you can only take what you can find and do your best with it, and then say, well, I've done that, I've used this, and within these sources, I've done that type of study, and within that, I've seen that tendency. So that's really more what I'm pleading, is that I'm more pleading that this type of methodology, especially on restricted sources, can show tendencies rather than, you know, I mean, I know I showed a lot of statistics, but I'm not at all claiming that this is sort of hard and fast science. But I think what this can show are tendencies for specific things or for specific evolutions, and I think that's where the interest lies.
Gwen?
Thank you. Hello, and thank you. I enjoyed that very much. I was just wondering, you've obviously done a lot of different sorts of inquiry. What doesn't work? What sorts of questions don't work for your kind of methodology?
It's a very good question. I think it's not so much what question doesn't work. It's more, and that comes back to what John was just saying, is what sources do we have? What material do we have? So that's why I'm saying every inquiry asks for specific research question, but in fact what I should almost also have added was we also need the right sources. So if we're going back to this very early things like what I did on the concept of consideration, so the sources are they're scant, they're difficult to access, and I had to do all sorts of things in order to sort of make them I could use them for my linguistic software. So therefore it reduces it reduces the sort of the results in a way. Whereas if you would do this on, a 20th century database of case law, then it would be a much more satisfying result from that point of view. So I wouldn't say you can't. There is no research question that works. I think it's just a question of how you're going to spin it, how exactly you're going to formulate what is exactly what you want, what you need, and then have you got the texts and the sources in order to be able to do it. So I would combine these several things in order to really make it a satisfactory study.
Louisa, did you have a hand up, or did I just miss that? Okay. Ian?
Hi, thank you very much for that. One point you mentioned consideration being associated more with a fairly narrow set of technical words. And one thing I was wondering about is that I think there's some point after about 1600 or so where a significant number of lawyers are struggling to compose texts in law French but are still doing it. And it does read very often like they're repeating rote phrases. And is there a way the methodology can handle that, or does it challenge it? Because if they're not fluently expressing themselves in the language they're writing in, does that get in the way of this kind of linguistic analysis?
That's a very good question. I'm not quite sure. So what it does is, it counts words. It counts the number of times a word occurs. So what you are suggesting is, because they're finding it difficult, they will say it again and again, and so therefore it shows more about their difficulty rather than about the content. Is that what you're saying?
It wouldn't necessarily in itself show the difficulty, I think, but it would certainly say that perhaps what they've written may not fully encapsulate what maybe they're trying to write, or what they're actually thinking, perhaps, maybe. Well, certainly from my perspective.
Well, of course, we never know what they were thinking, that's one of the problems. But so I think, so again, because, this is a lot of material, and I sort of had to rush through it. So obviously the methodology comes in from several angles. So it's the search terms, and then those lines that I showed you. But then and then you can count number of words, you can count proximity, what occurs in proximity of the search term, and there's all sorts of things like that you can do. So when you come at it from, and then there is the thing of actually going through the lines. If you have hundreds and thousands, that's quite a lot. But if you have several thousand, you can still go through the lines and actually look at it with your own human eyes. That's also possible. So what I would say is, Therefore, if you come in from several angles, then you need to compute all that information. So again, I would never just look at the statistics and go bang, 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 that's it. I would always want to double check it either by reading it through myself, looking through the lines with my own human eyes, rather than just rely on what the software says, and then try different types of collocations and clusters and all this sort of thing, and then see whether they come up with the same tendency. So it's always a question of tendency. That's what I was saying in answer to John. It's the tendencies that come out, and then when that comes out in a quite systematic way, then I think we are onto something. That's how I would say it.
I do see Louise's hand back up, so we will go to her. Yes? We don't seem to be getting any volume input if you are speaking. Okay, well, should we turn it over to Neil then?
Hi, thank you, Neil Goldfarb. My question is really, if it's okay, more about doing historical semantics generally, and sort of an epistemological question, which is when you're reading corpus lines, how do you know that you're understanding it correct, you know, in the temporally appropriate sense, as opposed to the intrusion of your current linguistic intuitions? And this really would probably only apply to something like the 18th century, where it's understandable to us, you know, to someone without special training, but at the same time there's variation, and sometimes it's clear that you're not understanding it and then you need to go to OED, but other times you think you understand it and it turns out that's not necessarily the case. I don't know if that's something you've encountered in your work, or if you know how that has been dealt with generally.
I wouldn't. So I mean, I think the understanding of the text will also come from obviously the context of what we're reading. So we're not just going. So I know the KWIC lines are sort of slightly abstract in the sense that they just take out bits of text, but I mean, I actually also know what it's all about. It's, you know, I'm looking at or case, I'm looking at you know, case law of a particular court or of a particular period, or in relation to a particular judge or something like that. So I think you know, therefore you understand what it is they mean, because it's within the context of the legal text. I wouldn't say that there is a lack of understanding from that point of view.
Okay, thank you.
Great. David, if you're next.
Yeah, it was context I wanted to talk about, because if you take something like consideration, it's perfectly clear there are different legal contexts within which a concept of consideration, or at least the language of consideration, will matter. So you're going to have to be able to predetermine on some basis, which is not linguistic, what the context is. So that means all the linguistic approach can do is to, I suppose, suggest a way that you might want to move your own understanding. Would that be right?
Yes, I think that's a very, very good point. The context is very, very important. And I didn't go into detail of what context. So you need, that's what I also mean a little bit about making sure that you get the right research question. Is so you need to be able to actually go and determine the context in which you are wanting to do this thing. So for example, if you're talking about consideration or about contract or about anything, if you're going to talk in equity, you will probably have different results than if you're going to talk in common law. So therefore you need to be really make sure that you're very precise of what exactly you sources you're going to use, and what you're looking for in relation to that source, in relation to that particular research question. I think all these things always need to be described in a very precise way and ring-fenced in a very precise way, because otherwise it will become just a generalization of not very interesting data.
Yeah, okay, thanks.
Paul?
Caroline, nice to see you,
Yes,
and nice to be able
nice
to
to
talk
see
to you. I was interested in the Tres Anciens Coutumiers work that you've been doing. But I thought that was really a very different kind of exercise from the other ones you were doing. There was no sense in which it was diachronic, and it was in some sense a normative or descriptive text. And we don't really know who it was written for, who used it, any of those other things. How useful to our understanding of 13th century Norman law is the kind of analysis that you were doing about the mentioning of men and women in the text? And do you think you could get equally interesting things out of it about the mention of children and adults in the text as well?
Yes, that's a very, there's an echo here.
Probably from me.
Oh, right. Okay. Right. Yes, that's a very, very good question, Paul. Thank you very much. So the coutumier was obviously, as a lot of this customary law, was written at the moment of political upheaval. The coutumier and the Sachsenspiegel is the same thing. You know, this is that we want to put down our customs because we are feeling threatened by what's going on in the political sort of from the political point of view. So to that extent, I think it is. Whether it's actually been applied in that way very, very strictly, we don't know, very probably not, but it's a reflection of what the society would have thought of what is important to write down, and because they were feeling threatened by outside forces. So from that point of view, I think it's interesting to see exactly what their view of women was expressed in that. And I think absolutely that you could do a study on children, you said, or on men, or on whatever. I mean, that is not. That is absolutely true, and it would also again reflect something of the views that they had of children or whatever other group you wanted to do, and you wanted to pick out. So at the moment I'm doing the same sort of thing on the Sachsenspiegel, and there again you can very interestingly you can do a study of Jews in the Sachsenspiegel, for example, and how are they mentioned, with what adjectives, with what. So I think it's a reflection not just of the law, but also of the attitude of society at the time. And of course, so what I didn't say is that this coutumier study is part of a larger study, which is going to consider a number of other sources, notably the Sachsenspiegel, but also other things. So it looks as though it's slightly sort of carved out, but it's actually part of a sort of larger study.
Well, that sounds very interesting.
And thanks very much for the talk. So I'm going to use my speaker's privilege to ask, my co-convener's privilege to ask a couple of questions. I had two questions. So one of them was, you mentioned how sometimes older words, older concepts from an earlier time would get repurposed for new ideas. So in a sort of form of bricolage, I guess. So I was wondering, are there linguistic qualities of some words which should make them more suitable for either having their purposes changed for new concepts, or if they're general words for being converted into legal terms?
Specific words or specific contexts?
So, do you notice when you see words which are converted into technical legal phrases, do they have similar qualities linguistically, or is it pretty random?
That's a good question. I think so. I think one of I think general language words, and so I think that's what's the attraction with the idea, with the study on consideration. General language words are very interesting to follow, because they come from a moment where everyone understands what they mean, and then they become something very, very specific. And I think the law is interesting in the sense that I think it's one of the special language. So within language, you have general language, and then you have specialized language, like language in the medical world or in the technical world or whatever. And so the legal language, I think, is actually a language which likes to take words which are common general language words and then turn them into something quite technical. Rather than the other way around, which tends to be or inventing new words. Not sure the law is so keen on inventing new words, to be quite honest. That's, I think, if you compare it to other specialized language areas like maths or computer science or whatever. So I think it tends to go into that direction, and then and then if it's organic, like law of contract is obviously one of those very organic evolutions, then it can take quite a long time, and it becomes a nice sort of thing to follow. Now, if you think about the environmental law, then there are a number of concepts, because that happened all so quickly. And there are a number of very interesting words that have appeared in environmental law, which are like totally new words. And I think that's, again, part because it was like, this is something that's evolved in such a sort of hurry and in such a sort of slightly chaotic way. So then maybe that's when new words get grabbed along. But I think in a sort of very easy evolution of concepts, I think then it tends to go from the general to the specialized.
Okay, great, thanks.
Do we have any additional questions? Well, in that case, thank you so very much, Dr. Laske. That was absolutely fascinating, and thank you to all of our attendees.
Thank you.
We will be back on the 1st of June with Dr. Kenneth Duggan on the subjects of Derrida's in 13th century England, and we hope to see all of you then. Thank you so much.